dear listeners. Welcome back to special podcast designed for long nights when you want to let your mind wander through real, life-dramatic stories that are thrilling yet relaxing and thought-provoking. Today, we will delve deeper and more detailed into two cases from the iconic program, Judge Judy, where justice is not only served but presented with straightforwardness, satirical humor, and life lessons as sharp as a razor blade. Imagine yourself lying in bed with dim bedside lighting, and I will guide you through the dark corridors of small claims court where ordinary people confront their inner and social conflicts. We will analyze each plot point profoundly, linking closely to real-life American law, and explore how Judge Judy's style, the judge with her sharp Brooklyn accent, uncompromising demeanor, and eyes that see through people, turns these cases into dramatic masterpieces. We begin with the first case of Fong versus Chung, a story of blind jealousy, domestic violence, and a resilient woman's journey to seek justice. Now let me paint a detailed picture for you of the first case, Fong sues Chung, or Manessa Fong vis. Albert Chung. This is a story that will make you shiver with its raw, harsh reality, but it also inspires with the resilient strength of the victim. Picture a freezing winter evening on January 27th, perhaps in a major city like Los Angeles, where the chill in the air heightens the tension. Manessa Fong, 45 years old, a community outreach coordinator whose job demands enthusiasm and the ability to connect people, is preparing for her costume performance at a dance school. She is the type of independent, strong woman who has likely spent weeks designing and rehearsing, hoping the evening will be a joyful release after tiring workdays. But then Albert Chung, 33 years old, her ex-boyfriend and a counselor with a handsome appearance, but harboring a volatile temper inside, enters the scene like a dark specter. The plot escalates from this point. Manessa recounts before the court with a trembling but determined voice, like a female protagonist in a psychological thriller film. Albert discovers the performance, perhaps through a random message or prior conversation, and jealousy erupts like a timed bomb. He insists on going with her, refusing any denial. Let us pause for a moment to analyze this plot point deeply. Jealousy is not a sign of true love. It is often a manifestation of control and insecurity. In real-world U.S. law, such coercive behavior can be an early indicator of domestic violence, as defined broadly in the Violence Against Women Act, VA of 1994, a federal statute passed by the U.S. Congress to protect women from abuse by intimate partners or ex-partners. VADUA not only addresses physical violence, but also emotional abuse, such as stalking or coercion, and can lead to charges under 18 U.S.C. or 2061A with prison sentences up to 5 years if the behavior crosses state lines or involves technology. In actual cases like United States v. Morrison 2000, the U.S. Supreme Court discussed VAOA's scope, emphasizing protection from initial controlling acts like this. At the dance school, the lively atmosphere with echoing music and sparkling lights quickly turns into a nightmare. Albert drags Manessa into a cramped, dark storage room, a private space where screams are hard to escape. There he begins yelling, calling her insulting names that demean her, and then, in a horrifying moment that leaves listeners breathless, he tries to burn her clothes, even pressing a lighter directly to her face, causing minor burns and leaving scars. Let us delve deeper into analyzing this plot point. The act of using a lighter in this way is clearly aggravated assault with a dangerous weapon under state criminal codes. For example, California Penal Code Section 245I1, where any item that can cause serious harm from knives to lighters is considered a weapon. In U.S. legal practice, similar cases have been handled harshly. For instance, in People v. Aguilar's 1997 in California, the defendant was sentenced to 10 years in prison for using everyday items in domestic violence. Judge Judy's style would interject here with her familiar bluntness. "What do you think you're doing, sir? Burning her face with a lighter. That's not jealousy, that's a crime. Don't try to excuse it to me with stupid reasons." She often uses a sarcastic tone to highlight the defendant's absurdity, making the courtroom audience nod in agreement and turning the case into a public lesson. Fortunately, Manessa escapes the storage room thanks to a knock from a stranger, a random element like a life-saving plot twist in films like Gone Girl or The Invisible Man, where the victim finds an escape in the final moment. But the nightmare doesn't end, it shifts to the next phase. As Manessa tries to drive away, Albert clings like a ghost, climbing into the car and sitting in the back, refusing to leave. On the highway home, he completely loses control, punching the windshield hard enough to crack it, trying to smash the side window, yanking the emergency brake, suddenly to stop the car amid rushing traffic, screaming wildly, and attempting to pull her out of the car with brute force. He even shouts threats. "I want to die with you." This is the dramatic climax of the entire case, listeners, a plot point that makes your heart race even just hearing it. Let us analyze this plot point more deeply to understand the legal consequences. Yanking the emergency brake while the car is speeding is reckless endangerment. Under state traffic laws like California's Vehicle Code Section 203103, which can result in up to 90 days in jail, a $1,000 fine, and even license suspension if repeated. The threat "want to die with you" is not mere words. It can be seen as a criminal threat under Penal Code Section 422, with prison terms from 1 to 4 years depending on severity. In real U.S. law, car-related cases in domestic violence are treated seriously, as in People v. Garcia 2005 in California, where the defendant was convicted for using a vehicle as a tool to threaten suicide or murder, leading to additional charges of domestic terrorism under VADOA. Judge Judy, with her no-nonsense style, would question Albert here. "Why did you pull the emergency brake? Because she drives dangerously? Come on, sir." That's how you turn yourself into the dangerous one. You have a hot temper, and that will land you in jail if you don't control it. Very luckily, patrolling police behind the car intervened in time, a fortunate detail like the hero's arrival in an action movie. They pull Albert out of the car upon discovering an open can of beer, violating the open container law prohibiting alcoholic beverages open in a moving vehicle under 23 U.S.C. 154, a federal law applying to all states. Albert claims the police threw him down on the road, roughly, but Manessa quickly seizes the opportunity to report at the local police station that very night, receiving an emergency protective order. Let us delve into this legal tool. A protective order is a crucial part of the U.S. justice system under California's Family Code Section 6200 et seq., allowing the court to bar the defendant from contacting the victim for an initial 7 days, extendable to a permanent order with evidence of ongoing danger. According to U.S. Department of Justice statistics, over 1 million protective orders are issued annually, but violation rates remain high at 40%, leading to additional criminal cases. In reality, the O.J. Simpson case, 1994, highlighted the importance of protective orders in domestic violence, though in that instance it wasn't enforced promptly. But that night doesn't conclude. This is the part that makes the story haunting and drawn out, like a horror film spanning the night. Manessa arrives home around 2 a.m., exhausted and panicked, then receives a voicemail from Albert, his voice full of rage, threatening her to pick up the phone immediately or bad things will happen. Just 15 minutes later, the doorbell rings incessantly like a death knell. She knows it's him, tries to call 911 for help, but he calls her phone simultaneously, blocking the outgoing call, a cunning and terrifying tactic prosecutable as telephone harassment, obscene or harassing telephone calls under 47 U.S.C. and 223 of Federal Communications Law, with fines up to $500 per call and jail time if repeated. Albert stands outside the door, demanding $35 for taxi fare aggressively, threatening to make a scene and wake the entire neighborhood if she doesn't comply. Manessa, in utter terror, has no choice but to pass the money through the door crack, hoping he'll leave. But Albert doesn't stop there. He forces her to open the door, and as soon as he enters the house, he grabs her like a predator, throwing her to the ground violently, making the floor shake. He pins her down, twisting her wrist, causing severe injuries to the spine and joints, wounds that Manessa later brings photos of as evidence. Then, in the darkest moment of the entire case, he attempts to rape her by pulling and tearing her pants. Manessa brings that tattered pair of pants to court as vivid evidence, silencing everyone with its brutality. Let us analyze this sexual assault plot point deeply. This is aggravated sexual abuse under 18 U.S.C. or 2241, the federal law defining rape or attempted rape with force, potentially leading to prison from 5 years to life. Tearing pants and using pinning force is attempted rape under California's Penal Code Section 261, and the defendant may have to register as a sex offender for life under Megan's Law 42 U.S.C. or 16901, a 1996 statute passed after the tragic Megan Kanka case. In real cases, like Harvey Weinstein 2020, and similar acts led to long prison sentences, underscoring U.S. law's increasing severity towards sex crimes and domestic violence. Throughout that long night, Albert continues abusing Vanessa in grotesque ways, threatening to make her drink toilet cleaner, a poisoning threat, potentially attempted murder if carried out under Penal Code Section 87, forcing her to inhale lighter gas, chemical assault, similar to using poison, and repeatedly threatening to kill her if she reports to the police. This is a classic chain of domestic violence behaviors, according to National Institute of Justice and IG research, where 1 in 4 American women experiences abuse from a partner, and 75% of cases go unreported due to fear of retaliation. Albert only leaves when Vanessa's mother calls around 9 a.m. Vanessa, with cleverness under pressure, convinces him to let her answer, because otherwise her mother would call the police immediately. This is a smart plot point, like the victim character in Jennifer Lopez's film, Enough, where wit saves a life. After Albert leaves, Vanessa calls the police and files a second report, but she states she doesn't want him arrested right away because she's too afraid of retaliation, a common phenomenon known as battered woman syndrome, recognized in U.S. law from the State v. Kelly 1984 case in New Jersey, where courts allow it as evidence to explain the victim's behavior. Vanessa decides to bring the case to small claims court after 4 months, as the process of putting Albert in jail through the criminal system is too stressful and could ignite his rage. She presents abundant evidence, photos of facial wounds, damaged floor rug from the struggle, broken cabinet doors and portable wardrobe, burned clothes, and even the police seize the lighter and Albert's burned clothes as exhibits. Now, let us turn to Albert's testimony and the dramatic confrontation before Judge Judy. This is where her style truly shines, transforming the courtroom into a stage. Albert, with a face trying to stay calm but showing clear tension, admits to pulling the emergency brake but excuses it as, "She drives quite dangerously because we were arguing." Judge Judy interrupts immediately with a sharp voice. "That's no reason to pull the emergency brake, sir. Do you think you're a professional driver, or are you just trying to control her?" She dismisses the excuse, pointing out that punching the windshield, which Albert also admits shows he has a hot-tempered nature, a pattern of violence under VAAA. Albert admits to the open beer can and being pulled out by police, standing on the road for an hour and a half waiting for a taxi, and being very angry. When Judge Judy asks why he returned to Vanessa's house, despite not living there, he replies that he was angry because she told the police he was causing her trouble. He admits demanding $35 for taxi fare and returning to the apartment after receiving the money, but denies touching her, saying it was only verbal arguing, and he stayed because he is legally blind, unable to drive late at night. Judge Judy doesn't believe a word with her familiar sarcastic smile. "Legally blind, is that a reason for you to stay and abuse her? Sir, I don't sympathize with excuses like that. You have a hot temper, and your actions are pure violence." She warns Albert to stay away from Vanessa, and if he approaches again, he'll face a judge like her who will throw him in jail without hesitation. The final ruling in favor of plaintiff Vanessa Fong for $5,000, the maximum in small claims court under California Code of Civil Procedure Section 116.220. Albert objects, saying if he did that, he would have been jailed after the police investigation, but Judge Judy ends with a sharp remark, "The police have evidence, and you're lucky not to be locked up yet. Don't test your luck again." Overall analysis of the case. This is a textbook example of domestic violence in America, where victims like Vanessa can sue civilly alongside criminal charges under tort law, seeking damages for assault and battery. Lesson: if you or someone is facing this, call the National Domestic Violence Hotline at 1-800-799-7233. This case reminds us that justice may come late, but it's always worth fighting for. Moving to the second case, a story less physically violent, but full of emotional scheming and financial lessons. McCall sues Willem, or Bourbon McCallvess, Sandra Willem, Imagine a cozy local bar in March where warm yellow lights illuminate weary faces after a workday. Bourbon McCall, 71 years old, a lonely elderly man with silver hair and a gentle smile but hiding deep loneliness, meets Sandra Willem, 32 years old, a young student struggling with life, perhaps attending college late and facing financial hardships. This chance encounter quickly turns into a lopsided relationship, where money becomes a tool for control. Bourbon testifies in court that he had a romantic relationship with Sandra and lent her a series of loans, starting with helping buy a car after her accident and DUI. Driving under the influence charge. He gave $2,300 to buy the Crown Victoria from Sandra's mother, emphasizing he wanted ownership rights, or at least a first priority lien to protect himself. Later, he continued lending $500 for hiring a lawyer and $500 for mortgage payments. However, he had no promissory notes at all, a fatal mistake that complicates the case. Let us analyze the first loan plot point deeply. The car purchase with a lion is the key element under Uniform Commercial Code, UCC Article 9 Federal and State Law governing secured transactions. A lien allows a creditor like Bourbon to repossess the asset if the borrower doesn't repay, per UCC for 9609, but it must be done peacefully without violence. In U.S. legal practice, similar cases like Capital One Auto Finance v. Debtor 2015 confirm that a lion is strong evidence of debt, and courts often favor the creditor if documented. Judge Judy's style would interject, "You lent money without papers, sir? You're foolish? Do you think this is a romance movie where money falls from the sky?" Sandra, with the resolute voice of a young woman fighting for her freedom, counters that Bourbon wanted more from the relationship than she could give. He tried to control her with money, and when she rejected his romantic advances, he became increasingly hostile. Finally, she agreed to return the car to avoid further harassment. Judge Judy questioned Sandra sharply. "You say he never gave you any money?" "Really? Send the car title transfer right here." She shows skepticism with a sarcastic smile. "Do you think I can't see through these games? He's overly intrusive, but at least he has a lion on the car." Deep analysis of the emotional control plot point, this isn't direct criminal offense, but it can relate to harassment if prolonged under California's Penal Code Section 646.9 for stalking. In U.S. law, such cases often fall into small claims court where judges rule based on simple evidence without lawyers. Sandra's DUI adds complexity. DUI law under 23 U.S.C. and 164 requires states to have strict measures like vehicle forfeiture if repeated, potentially affecting her borrowing ability. Judge Judy's ruling, she finds Bourbon overly intrusive and foolish for lacking contracts on cash loans under the statute of frauds, California Civil Code Section 1624, requiring written agreements for over $500. Thus, she dismisses the rest of the claim, but recognizes the lion on the car, allowing Bourbon to reclaim it. Sandra feels Bourbon used the car as leverage to build an unwanted relationship, while Bourbon thought the 40-year age gap was harmless and accuses her of lying. Lesson from this case: always have clear contracts for loans, like a promissory note, to avoid disputes. In reality, millions of small claims in the U.S. each year involve personal debts, per National Center for State Courts reports. Dear listeners, as the late night descends and the wind outside whispers, these two cases from Judge Judy remind us of human complexity. From jealousy leading to violence in Fong vs. Chung to control through money in McCall vs. Wellham. Through the lens of U.S. law with VA to a UCC and small claims courts, we see justice isn't always swift, but it exists for those brave enough to fight. Judge Judy's style teaches us to face truth head-on, and the biggest lesson is, protect yourself, learn from mistakes, and remember true love isn't control. Sleep well and dream of a fairer world. Thank you for listening to Whispers from the Courtroom. See you in the next episode. Today we dive into a case from the legendary television show Judge Judy, where justice is served swiftly and sharply, but always leaves profound lessons about love, responsibility, and the fragile line between personal emotions and American law. The case we're exploring today took place in the early 2000s between Jared Day, a young 22-year-old liquor store manager with a handsome but impulsive demeanor, and Tammy Foster, A 33-year-old former security guard, strong yet emotionally vulnerable. This isn't just a dispute over money, it's a tale of broken love, flawed verbal agreements, and the consequences of impulsive actions and anger. Before delving into the details, let me set a broader context about the American legal system, as this case perfectly illustrates how civil law operates in this country. In the U.S., small claims cases like this are handled quickly in local courts, with compensation limits often under $10,000, depending on the states. In California, where the show is filmed, it's $10,000. Judge Judy represents arbitration, where parties agree to let her decide instead of a formal court, and her rulings are legally binding. The case revolves around three main issues: unpaid rent, harassment, and defamation leading to job loss. We'll break down each detail thoroughly, linking to real laws like the Federal Fair Housing Act of 1968, the Uniform Commercial Code for Contracts, the Civil Rights Act of 1964, and landmark Supreme Court precedents, so you understand why justice isn't always a clear win, but a balance of rights and duties. Let's start with the opening of the case, where Jared Day, with a youthful but frustrated voice, stands to present his claim. He is suing Tammy for unpaid rent after she moved out of their shared apartment. According to the records, they moved in together on August 15th, 2000, signing a joint lease for a 2-bedroom apartment. In American law, a lease agreement is a binding legal document, usually for 6 to 12 months, and when signed jointly, the parties are jointly and severally liable. This means the landlord can demand the full amount from either party, and if one leaves, the other might shoulder the entire burden, a rule reinforced by tenant protection laws in many states to shield landlords from financial risk. Jared says Tammy moved out around March 16, 2001 after paying for March, and he demands payment for April, May, June, and July. But Judge Judy, with her razor-sharp experience, quickly clarifies Jared found a new male roommate starting May 1st, so only April is truly at issue. She emphasizes the principle of mitigation of damages, reducing losses in U.S. civil law, suck tort law, where the plaintiff must try to minimize their harm and can't claim compensation for parts already fixed. If Jared hadn't found a roommate, he could have demanded the full amount, but he did, so damages are limited to April. Now, let's delve deeper into why Tammy left, a detail full of drama that makes the case as captivating as a romance movie. Tammy explains they broke up in January 2001, but agreed to live together until the lease ended to avoid financial hassle. They had a verbal agreement. Neither would bring an opposite-sex partner into the home while both were still paying rent. This is a classic example of an oral contract in American law, recognized under the Restatement Second of Contracts, a guiding code most states follow. Oral contracts are valid if intent to bind and exchange of value can be proven. Here, it's sharing rent. However, they're disputable without written proof, and Judge Judy skillfully exploits this. Tammy says Jared started a relationship with Andrea, a woman he met online, with late-night chats and long phone calls that left her emotionally distressed. By February, she couldn't take it and decided to move out on March 10th, earlier than planned. Judge Judy asks sharply, why did Tammy choose to leave instead of asking Jared to go? Tammy replies that Jared was sometimes sweet, trying to get close, even sleeping together, then turning into a jerk, and he never offered to leave. The judge agrees that Jared's behavior made the atmosphere unlivable, uninhabitable emotionally, reminiscent of constructive eviction. In U.S. rental law, an implied eviction where the other party can terminate the lease without liability if there's a serious breach, though usually for physical issues like breakdowns. Here she extends it to emotional factors, showing law's flexibility in small claims. She rejects Jared's argument that the agreement only applied while both lived there, calling it stupid because at the time of the deal, no one anticipated changes. This is a profound psychological analysis. People plan on ideal assumptions, but life is full of surprises, and law must adapt to reality. The climax of this part is when Tammy discovers proof of Jared's violation. She sent the rent check for April, but that weekend, when visiting the apartment to do laundry, with Jared's permission, she found photos of Andrea in the home, dated photos. showing they were together early in April, even on a romantic getaway to Estes Park and the famous Stanley Hotel's a Colorado landmark evoking Stephen King's The Shining, adding a cultural layer. Tammy, emotional, left a note by Jared's computer and stopped the check payment immediately. She called the landlord explaining the situation. In American law, a breach of contract can excuse the other party's obligations under the material breach principle. If serious, the harm side can end it. Judge Judy rules. Jared gets no April rent because he broke the agreement first by bringing Andrea in. She quips sarcastically, "Hey, and Andrea should have a very good time in the apartment." Jared's lawsuit is dismissed entirely, a lesson in proving actual damages and not exploiting situations for gain. Shifting to Tammy's counterclaim, this section is even more dramatic, touching sensitive issues like harassment and defamation, common in bitter breakups. First, on harassment. Tammy says after moving out on March 10th, Jared called almost daily, initially friendly, saying he missed her, inviting her over, but growing angrier. He heard her new male roommates, two guys fixing up the new place, in the background and made crude comments. "Who's that?" "Your new boyfriend. A girl with two guys, huh. You're throwing a party." These were jealous, insulting remarks, but in American law, harassment under the Civil Rights Act of 1960, or state laws like Colorado's anti-harassment laws requires repeated actions causing fear or threats to safety. The peak was when Tammy needed lease application papers for her new place. Jared stormed into her home, stomping loudly through the house, down to the basement, throwing the papers at her, then stomping out. Witness Dan, her friend, could confirm, but Judge Judy dismisses. That's not harassment, just bad behavior. She's right. Per Supreme Court precedent like Meritor Savings Bank v. Vinson from 1986, harassment needs severity and pervasiveness, not just angry calls or impulsive acts. The defamation and job loss part is the heart of the counterclaim, full of surprising twists like a detective novel. After Tammy stopped the April check, Jared emailed her workplace, a security company. The email accuses Tammy of blackmailing him by threatening to tell his brother, who loaned money, that he used the funds to buy equipment for growing marijuana, hydroponic gear, implying illegal pot farming, unlawful in the U.S. then, before legalization in some states from 2012. Jared wrote, "I fear she might blackmail me even through my mother and brother. Who knows what else she could do." He added, "And they want to stay anonymous so Tammy Foster doesn't come and shoot me." Tammy admits planning to tell Jared's brother about the misused money, but not blackmail, just stating facts. In U.S. defamation law, per the landmark New York Times v. Sullivan from 1964, you must prove falsity, harm, and actual malice if the victim is public. For ordinary folks like Tammy, negligence suffices. Judge Judy dissects Jared didn't lie about Tammy using the office computer for chats, actually with Tristan, but similar to Andrea. On blackmail, it was Jared's fear because he was doing wrong growing pot, not a direct threat from Tammy. On shooting, then Jared wrote, "In my mind, I fear she might shoot me if she finds out. This is personal opinion, protected by the First Amendment, per Milkovich v. Lorraine Journal Co. from 1990, where opinions aren't defamation if not implying false facts." The fallout for Tammy was severe. The email triggered an internal meeting, a report, and a note in her file. When the new boss arrived, say after the old one was fired, he reviewed files and fired her after just 4 days, costing her a $10,000 annual raise opportunity after 2.5 years on the job. In U.S. employment law, under the Employment Act, well doctrinally in most states except Montana, workers can be fired without reason unless proving discrimination, a title valor of the Civil Rights Act or retaliation. Tammy lacks a witness from the new boss proving the email was the direct cause, missing the burden of proof, a core U.S. legal principle bolstered by McDonnell Douglas Corp. v. Green from 1973. Judge Judy dismisses. He didn't say anything false. Of course it might harm her reputation, but he just expressed fear. She highlights the difference between direct accusations and personal thoughts, a deep analysis showing why American law prioritizes free speech over emotional protection. Final ruling. Both Jared's suit and Tammy's counterclaim are dismissed. No one wins, but both learn. Post-ruling, Jared comments, "I'm just glad to be rid of this psychotic mess. I will never drag someone's career into a dispute." Tammy retorts bitterly, "I tried to work for the company for 2.5 years and it's gone. The breakup was between us. I lost a really good opportunity," she adds. He's seeing a girl he barely knows in Chicago who's a stripper. Jared fires back, "I think she's crazy." And Tammy ends, "I was going to call his brother and tell him what the loaned money was really used for." These words, laden with emotion, remind us that behind every case are real people with pain, regret, and sometimes petty revenge. This case isn't isolated. It mirrors broader early 21st century American society, the internet boom sparking virtual affairs, like Jared and Andrea, age gaps in relationships, and risks of cohabitation without clear written deals. Compared to other cases, like those on People's Court or real California court filings, themes recur. Leases spark disputes and breakups, and email defamation surges in the digital age, leading to laws like the Communications Decency Act of 1996 protecting platforms but not individuals. The biggest lesson in love: sign clear contracts in anger. Control your words, as they can alter lives. As you drift off to sleep, reflect on these characters: Jared, the impulsive young man, learning actions have costs; Tammy, the resilient woman, realizing justice doesn't always mend emotional wounds. Life is like a courtroom full of surprises, but truth emerges. Good night, and dream of benches where justice prevails in its own way. See you in the next episode of Midnight Courtroom, where we uncover more legal enigmas. Tonight, we'll talk about a case that's not a murder or a huge property dispute, but a story about friendship, kindness, and a little dog named Pepper. This is the lawsuit between Carolyn Carpenter and Shiri Licata, inspired by an episode of the Judge Judy show, a program I always love because it reveals human nature in the most authentic way. We'll explore whether a little dog is just property, or does it carry deeper emotional meaning? And when kindness is abused, which side does the law stand on? This story will be long detailed, so you can close your eyes and visualize each scene, like watching a slow movie. Relax, take a deep breath, and let me begin. Las Vegas, the city of neon lights and shattered dreams, is not just a place for gambling, but also a stage for everyday dramas. That year, around the early 2000s, Carolyn Carpenter was a middle-aged woman who loved animals so much that she could be called the mother of all species. She moved to a new apartment complex, bringing along a furry family. Initially, her testimony was a bit messy. Sometimes 2 dogs and 1 cat, sometimes 3 cats and 1 dog, then 2 cats and 1 dog, even 3 dogs. Judge Judy, with her sharp experience, simply concluded, "She has too many animals." And indeed, the apartment management didn't allow it. They sent a notice: reduce the number of pets or leave. Imagine Carolyn, a busy woman working at a small publishing company, suddenly facing this difficult decision. The animals weren't just pets, they were companions, a source of comfort in her lonely life. She probably spent hours petting them, feeding them, and talking to them like children. But rules are rules, and in Las Vegas, where life is already harsh with the desert heat, finding a new home for pets isn't easy. Carolyn might have paced her small apartment that night, the walls closing in, wondering how to juggle her love for her furry friends with the cold reality of lease agreements. This wasn't just about paperwork, it was about family, or at least that's how she saw it. Carolyn was in a dilemma. She worked at a small publishing company, where the boss, the magazine owner, was uncompromising about bringing pets to the office. That's when Shiri Licata appeared like a savior. Shiri was the press manager at the same company, a middle-aged woman with 4 dogs and a lot of compassion for animals. According to Carolyn, they knew each other through work, not close friends, but enough to trust each other in emergencies. Imagine that office: messy desks with papers, old computers, and the tense atmosphere of deadlines. Carolyn brought Pepper, little dog born on July 7, 1999, the child of another dog she owned, to the office in an urgent situation. Pepper was then over 1 year old, a cute little dog with soft fur, sparkling eyes, but also mischievous enough to cause trouble. Carolyn needed a temporary place for Pepper, because the apartment didn't allow it. And so, the story began: a verbal agreement, no papers, just based on trust. In moments like this, people often act on emotion, not thinking about legal consequences. But as we'll see, this ambiguity led to conflict. Perhaps Carolyn felt a rush of relief in that moment, handing over the leash, believing her problem was solved, unaware of the storm brewing. Let's pause for a moment to analyze this detail more deeply. In American law, especially in Nevada where the case happened, animals are considered personal property, similar to a bicycle or furniture. According to Nevada Revised Statutes NRS 570, 4.110, abandoning an injured, sick, or disabled animal is illegal, considered a misdemeanor with fines up to hundreds of dollars and possible short-term imprisonment. But Pepper was healthy, and this wasn't abandonment, but temporary keeping, a form of bailment, where one party hands over property to another for temporary care. Bailment in American law is an implied or oral contract where the keeper bailee, here Sharid, has a duty of reasonable care, but the owner bailer, Carolyn, must bear the costs and retrieve it in time. If not, it can turn into abandonment, allowing the keeper to dispose of the property, like selling or giving away, after reasonable notice. The Humane Society and police that Shuri consulted later are based on this principle. In Nevada, if the owner doesn't contact for a long time, the keeper can consider it abandonment, and the law allows them to find a new home for the animal to avoid unnecessary costs. To illustrate, think of cases like State v. Cleveland, Nevada, where the court determined abandonment based on time and lack of support similar to this case. But at this point, everything was still fine. Carolyn brought Pepper to the office, and the incident happened urgently. The sun beat down mercilessly outside, a typical Las Vegas afternoon, amplifying the urgency of the moment. From Carolyn's perspective, Shuri voluntarily adopted Pepper. Imagine the scene vividly: a scorching day in Las Vegas, temperature perhaps up to 100 degrees Fahrenheit, Pepper tied outside the office under scant shade, barking and whining from the heat and loneliness. The boss wouldn't let it in. Carolyn worried, sweating, trying to persuade, but in vain. Sherry, with a kind heart, saw it and stepped out, petted Pepper for a while, then said, "I'll adopt it. I already have 4 dogs. I'll adopt it." Carolyn said this happened on November 30, a day later than Sherry's version, and we'll analyze this conflict later because it's key to assessing the reliability of the testimony. Carolyn was very grateful, perhaps quickly hugged Sherry, eyes teary. She gave dog food, ear drops to treat common ear infections in dogs, and promised to pay Sherry for care. "I plan to call family or friends to find a caretaker later," Carolyn said, her voice full of hope. She didn't visit Pepper because that would be the worst thing I could do to that dog. Afraid Pepper would remember her scent, would be sad and cry, making the situation worse. Instead, she believed Pepper was in very good Christian hands, and Sherry loved it like her own child. Imagine Carolyn going home that night, lying in bed, thinking about Pepper and smiling, feeling temporarily relieved. The weight of the day lifted, replaced by a fragile sense of security. December passed. Carolyn and Sherry talked about the dog every day, at the office perhaps during lunch breaks. Sherry telling how mischievous Pepper was, Carolyn laughing and asking about health. These conversations built a bridge of trust, small talk turning into shared concern for the little creature. Then on January 5, Carolyn quit her job in unpleasant circumstances, perhaps arguing with the boss about deadlines or pay. She stormed out of the office in tears. She needed to stabilize her life, find a new job, pay bills. The loss of income hit hard, adding layers to her stress. On January 15, she called Sherry from some coffee shop. "I want to arrange to pick up Pepper after I pay February rent." Carolyn's voice probably trembling, full of anticipation. And on February 5, Carolyn came to the old office with an open checkbook, ready to pay perhaps $10 per week plus interest, to show gratitude. She had rehearsed this in her mind, a moment of redemption. But Pepper had disappeared. Sherry had given away the dog to a woman in a wheelchair who needs a companion. Carolyn felt betrayed, like stabbed in the heart. She sued Sherry for compensation, perhaps the value of Pepper around a few $100s, plus emotional damages that American law increasingly recognizes. In Carolyn's eyes, this was malicious action, violating trust. Let's pause to analyze this detail deeply. Carolyn's testimony shows a picture of gratitude and clear plans, but lacks specific actions. She had 3 of Sherry's phone numbers, but didn't call after January 15. Why? Perhaps busy job hunting, but in law, this can be seen as lacking diligence in maintaining ownership rights. In America, in bailment cases, the owner must prove they didn't abandon the property. According to federal and state precedents, like in Jones v. Kelly in California's near Nevada, if the owner doesn't contact within a reasonable time, usually 30 to 60 days, the keeper has the right to assume abandonment. In Nevada, NRS 570, 4.100, and related cruelty prevention laws allow the Humane Society to intervene if the animal is neglected. Carolyn could argue this is gratuitous bailment. It's a free keeping where Sherry has higher responsibility, but she promised to pay $10 per week, turning it into bailment for hire, where responsibility is shared. The conflict over the pickup date, November 30 vs. October 12, is key. If November 30, the keeping time is shorter, Carolyn has more reason. But the note from Sherry's apartment manager mentions October, supporting Sherry. This makes Carolyn's testimony less convincing, as it suggests she might be covering up a longer time without support. The emotional toll on Carolyn must have been immense, turning a simple favor into a legal battle. Imagine Carolyn's emotions. Lost job, lost dog, lost friend. She probably cried every night, wondering where Pepper was, if it was loved. But did she really care for Pepper? We'll see from the other perspective, where everything flips. The contrast between the two women's accounts highlights the subjectivity of memory and intent, a common theme in courtroom dramas I've scripted. Now, let's switch to Sherry smoothly so you feel the contrast. Her version is different, and this is where the real drama explodes like a plot twist in a movie I've written. Sherry said Carolyn brought Pepper to the office on October 12, nearly 2 months earlier than Carolyn, extending the keeping time and increasing the burden. The boss wouldn't let it stay in the office. Carolyn tied it outside in the heat. Sherry pitied seeing Pepper whining under the sun and said, "Bring it to my house for the day." Then, Carolyn asked to keep it for a few days to convince her brother and his girlfriend to adopt. Sherry agreed, thinking it was temporary. Imagine Sherry going home that night, introducing Pepper to her 4 dogs, perhaps a few chaotic barks, but Sherry patient, feeding, cleaning up. The house, already lively with her own pack, suddenly felt even more crowded. And a few days became a few weeks. Carolyn promised, "I'll pay $10 a week." She gave a large bag of dog food. "I don't have money." "Is this enough for the first week?" Sherry received $10 after the first week, another $10 after 2 weeks, total $20. No more from January 5 to February 5. Sherry loved Pepper, petted it every evening, but the dog didn't get along with her 4 dogs, would never integrate. Perhaps biting, chaotic barking, messing up the house. Pepper also caused damage, chewed on the lace curtains that Sherry loved, soiled the bed sheets, perhaps leaving smells and stains hard to wash. These incidents piled up, turning affection into frustration. On January 5, Carolyn quit suddenly, stormed out of the office without saying anything about the dog. According to Sherry, a detail that heightens the feeling of abandonment. Sherry might have felt a pang of worry in that moment, but life went on. After that, Sherry only heard from Carolyn once, when she called the office and promised to call back. In mid-January, the apartment manager sent a notice must pay $400 pet deposit if keeping Pepper in February. Sherry had no money, perhaps struggling with her own bills. She tried calling Carolyn, but the number is no longer in service. Sherry refused a friend of a friend who wanted to adopt Pepper because she believed Carolyn would pick it up. But time passed, costs accumulated, and Sherry felt trapped. The pressure built like a slow burning fuse. Finally, she gave Pepper to a woman in a wheelchair who needs a daytime companion, because the doctor advised adopting a dog or cat for health. This person was the mother of a friend's friend. Sherry didn't know the name at first, but under pressure from Judge Judy, she provided the neighbor's name, Mary, who knew the esthetician. Pepper bonded immediately, as if fated. Imagine the scene: the woman in the wheelchair, perhaps lonely during the day when her daughter goes to work, pets Pepper and smiles for the first time in a while. For Sherry, it was a bittersweet handover, relief mixed with a touch of sadness. Sherry countersued for care costs, food, medicine, and house damages. She called the Humane Society and police department. They confirmed she had the right to give it away because it was considered abandonment. Sherry's version paints a picture of kindness being abused, like a supporting character exploited in a movie script. Let's analyze deeply in Nevada law. If the owner doesn't support costs and doesn't contact, this is abandonment under NRS 570. 4.110, though, for sick animals, but extended to neglect cases through precedents like People v. Spiegel in California, where the court saw lack of support as evidence. General American law, according to the Animal Legal Defense Fund, allows the keeper to sell or give away after 10 to 20 days' notice, as in California, but similar in Nevada through local regulations. Sherry didn't give formal notice, but calling the Humane Society was a reasonable step, showing she tried to comply. The date conflict. The manager's note confirms October, making Sherry's word more credible. The detail of Pepper causing damage emphasizes nuisance, supporting the countersuit under tort law. The owner is responsible for damages caused by their property, as in restatement, 2nd of Tort Section 157. Sherry probably felt relieved giving away Pepper, but also guilty because she loved the dog. This internal conflict adds depth to her character, making her more than just a defendant. Let's reflect, is Sherry a betrayer or just a victim of irresponsibility? This story reminds us of the thin line between kindness and burden, especially in American society where individuals must fend for themselves. In a culture that prides self-reliance, acts of generosity can quickly turn sour without clear boundaries. Now we come to the courtroom, case number 100, Carpenter v. Licata. Imagine the courtroom, Judge Judy sitting behind the wooden bench, bright lights, the two sides standing tense, audience whispering, the air thick with anticipation, the gavel ready to fall. She pointed out the date conflict. Carolyn said November 30, Sherry October 12, and the manager's note supports Sherry. No malicious action, she declared, voice firm. The judge criticized Carolyn. Between January 5 and February 5, you didn't support the dog. No food, no $10 a week. As a dog lover, she said, I called to check on my dog every day more than my kids. You only called once. You abused her good nature. What did you expect her to do with the $400 deposit? Carolyn defended, perhaps stammering about financial difficulties, but weakly, her face flushed, words tumbling out in defense. Sherry told about the Humane Society and police, voice calm but firm, standing tall. This is the climax of the drama, like the peak in a movie. The judge applied the reasonable person standard. What would a reasonable person do? In American law, the court considers intent and behavior. Carolyn's lack of contact violated the bailiff's duty. Legal connection in California near Nevada, AB 2274 from 2018 distinguishes pet custody and divorces, treating dogs as community property. But considering welfare, Nevada is similar through NRS 574, but here it's a civil suit, not criminal. If Carolyn proved a clear oral contract, she could win, but the conflict weakens it. The detail of Sherry not knowing the recipient's name at first shows lack of transparency, but under pressure, she provided it, proving no hiding. Judge Judy, with experience from thousands of cases, saw through the essence. This wasn't theft, but the consequence of irresponsibility. Her words cut like a knife, exposing the flaws in Carolyn's story. The verdict came quickly, like a slap. Carolyn's lawsuit dismissed. Get out of here. Sherry's countersuit also dismissed. That's the risk when you have little dogs. Goodbye. After court, Sherry said she didn't ask to get the dog back. I called the Humane Society and police. They said I was right. Imagine Carolyn leaving the court, shoulders slumped, perhaps regretting not contacting more. The echo of the judge's words ringing in her ears. Sherry sighed in relief, but probably still thought about Pepper, wondering if it was truly happy. Let's analyze the verdict more deeply. The judge prioritized Pepper's welfare. The dog now has a good new home with someone who needs it. In modern American law, courts increasingly view pet welfare over property rights, like in New York with Travis v. Murray in 2013, where the court weighed the best interest for the pet. Nevada is following this trend through animal protection laws. Less than oral contracts are dangerous, always document, like emails or papers. In Nevada, avoid abandonment by regular contact and supporting costs. This story isn't just a lawsuit, but a lesson about friendship. Kindness has limits. Responsibility is key. Think about times you've helped friends. Is there a boundary? And with pets, they're not objects, they're lives needing care. As the courtroom doors close behind them, the real resolution happens in quiet reflection. The story ends, but the lessons remain. Pepper is probably happily chasing shadows or curling up with its new owner now. Carolyn learned about responsibility, Sherry about the limits of kindness. In the American legal world, where animals are gradually recognized rights, this case reminds us to live responsibly. I hope this story helps you relax, reflect on life. Good night, and dream of loyal dogs, true friendships. In today's special extended episode, we'll dive deeply into two real life cases from the legendary courtroom show of Judge Judy Shaindlin, heard in the Small Claims Court of Spokane, Washington in the early 2000s. These cases are based on authentic testimonies, real rulings, and I'll bring them to life with intricate detail and captivating storytelling, complete with in-depth analysis of the events and tight connections to real-world American law, particularly in Washington state. So lie back comfortably on your bed, turn off the lights, and let me guide you through this journey. A leisurely, immersive experience filled with surprises, surging emotions, and reflections to help you drift into a deep, peaceful sleep with a calm heart. Before we dive into the first case, let me set the stage for you. Spokane, Washington, in the early 21st century, was an industrial city of about 200,000 people, where daily life revolved around work, family, and the quintessential American dream. The Small Claims Court here, governed by Washington's revised code, RCW Title III, handled disputes up to $10,000 without requiring lawyers, emphasizing swift and equitable justice based on evidence and testimony. Judge Judy, with over 20 years as a family court judge in New York before her TV fame, brought a razor-sharp, no-nonsense approach to her rulings, prioritizing truth and personal accountability. The cases we'll explore today aren't just legal battles. They're testaments to how American law protects individual rights within the context of family and society, guided by the U.S. Constitution and state statutes. Let's begin with the first case, a family feud brimming with drama, where sisterly bonds are pushed to the brink by petty debts, personal property, and betrayed trust. This is the story of Carrie Miller, a 20-year-old young woman struggling to find her footing as a customer service representative, earning $7.50 an hour, a modest wage but enough to dream of independence. She's suing her own flesh and blood sister, Chris Rogers, 33 years old, a professional clown, a job that sounds cheerful, performing at birthday parties and events, but whose life is steeped in family turmoil, from raising 4 children to navigating complex relationships. Also dragged into the lawsuit is Rick Olson, Chris's boyfriend. Though he's quickly dismissed from the case as uninvolved, Carrie demands the return of personal belongings. She claims her sister unjustly kept, while Chris countersues for unpaid rent and a small loan, a seemingly straightforward dispute that unearths layers of deep-seated conflict. This case isn't just about material possessions. It's about Carrie's delayed journey to maturity, Chris's repeated generosity being exploited, and the fractures within a typical American family, where love is often tested by money and responsibility. Let's paint a vivid picture of Carrie's life to help you understand the context. This young woman has been on an unstable journey, reflecting the precariousness of youth in America during the 2000s, as the economy recovered from the dot-com bust. From her parents' home in Creston, Washington, a small, tranquil town with sprawling wheat fields and crisp air, where life centered on agriculture and family, Carrie set out to chase her dreams of college and a job in Spokane, a larger city with more opportunities. She briefly stayed with another sister, Julie Eddy, for just 3 weeks, with no major issues, before moving to Chris's house on February 22nd, 2001. Why? Chris had a computer, a luxury at the time, making it easier for Carrie to browse job listings online, especially with sluggish and costly dial-up internet. But this wasn't Carrie's first time living with Chris. Back in August 1998, at 18 years old, she stayed with her sister in Anchorage, Alaska, a frigid city with endless winter nights, where Chris worked as a clown and needed childcare. Back then, Carrie earned $250 a week as a nanny for Chris's kids, a generous sum for a teenager, giving her valuable life experience. This time in Spokane, Carrie started babysitting for Chris on weekends. When her sister would go out with friends and often return drunk, details that sketch a portrait of a Chris stretched, thin, juggling work, motherhood, and a chaotic personal life, while Carrie was still searching for her own path. The real drama erupts when Carrie decides to leave Chris's home after just 6 weeks on April 1st, 2001, an April Fool's Day dripping with irony, as if life itself were playing a cruel joke on them. The departure wasn't peaceful, likely. Heated arguments about money and duties left lingering wounds. The official reason Carrie's father, a pragmatic man from Creston, secured her an apartment after she landed a steady job paying $7.50 an hour, enough to live independently, though barely. But Carrie left behind a pile of personal belongings, an old but cherished TV, the CD tray of a stereo system, items that brought comfort after long work days, some clothes, shoes, glamorous prom dresses that Chris had sneakily taken from their mother's house in Watchie to wear for her clown performances, and notably a wardrobe full of memories, plus 7 sets of bed linens, a number so extravagant that Judge Judy chuckled skeptically. Even an unemployed person doesn't need 7 sets for a single bed. Are you living like royalty? Carrie insisted her mother bought them, gifts born of familial love, but this detail highlights the exaggeration common in emotional lawsuits, where memory is distorted by anger. Chris admitted to keeping the TV and wardrobe, and even recounted finding the CD tray and linens in a trash bag in the garage while cleaning for a yard sale. A vivid image of the chaos in the home of a mother of 4, where belongings get lost in the whirlwind of daily life. Now, let's delve deeper into Chris's countersuit, where the conflict reaches its peak and reveals intricate psychological layers. Chris, with a voice heavy with frustration, recounted how Carrie begged, even pleaded, to move into her home because it was more luxurious than Julie's, with a computer, a private room, and full amenities, unlike the cramped conditions at their parents' or Julie's. She insisted this time wouldn't be free. Carrie had to pay $200 a month in rent, plus food expenses, and repay a small loan Chris gave her for essentials. Chris proudly shared that she helped Carrie find a job through her network, and Carrie only started working 2 weeks before moving out, a sisterly gesture of support. But Judge Judy, with her decades of courtroom experience, quickly spotted the flaw. With such a low wage, how could Carrie afford 2 months' rent, February and March, when she wasn't stably employed? You're demanding money from a young woman earning just $7.50 an hour. That's not helping. It's a burden. The judge's words cut sharply, leaving Chris flustered. This leads to the case's most dramatic contradiction, a moment straight out of a scripted drama in her initial court filing. Chris wrote that she was good sister, taking Carrie in when she needed help without asking for a single cent, and this is how I'm repaid. A betrayal that stings. But in court, Chris scrambled to clarify that this statement applied only to Carrie's earlier stay in Alaska, when she was 18 and paid as a nanny. This time in Spokane was different because Carrie was 20, no longer working for her, just living there, and Chris demanded rent to teach her responsibility. Judge Judy shook her head. You can't change your story midstream like that. Testimony must be consistent, or the court won't buy it. Chris, her voice trembling, vented about her family history. Every member, from parents to siblings, had stayed at her house for free, used her amenities, and even pilfered small items. She detailed Carrie's habits, going home to their parents on weekends, getting pocket money, but spending it on frivolous things, never repaying debts. Our mother kicked Carrie out because she was useless, stealing small things and doing foolish stuff. Chris said, her tone bitter. She admitted Carrie was not fully cooked, a poignant metaphor, At 20, she's still a green apple, not yet ripened into adulthood. Chris also opened up about herself with 4 kids and her own youthful mistakes. She understood that feeling, but was exhausted by being taken advantage of repeatedly. From a real-world legal perspective in America, this case is a classic example of oral contract disputes within families governed by Washington's Residential Landlord-Tenant Act's RCW 59 Win Eve. In Washington, month-to-month rental agreements can be oral and legally binding if under 1 year, but they must be proven through specific conduct, like staying long-term and using amenities without objection. However, RCW 1936 Statute of Frauds mandates that agreements for loans or debts over $500 require written documentation or credible witnesses to be enforceable in court. Below that, consistent testimony is key. In Spokane's Small Claims Court, where disputes up to $10,000 are handled without lawyers, judges rely on the reliability of testimony and indirect evidence to rule per RCW 1240, Small Claims Act. Chris's contradiction, from not asking for a cent to demanding $200, weakened her case, leading to the complete dismissal of her countersuit. This reflects a core principle in American law. Courts don't uphold implied contracts if there's evidence of inconsistency or exploitation, especially in family dynamics where emotions often cloud reason. In practice, such cases are often encouraged to resolve through mediation under Spokane County's court programs. But when litigated, rulings hinge on clear evidence to avoid prolongation. Regarding Carrie's belongings, this is a replevin action, a legal term for recovering personal property wrongfully withheld under RCW 7.64 in Washington. This law allows plaintiffs to request a court-issued writ of replevin to retrieve items immediately without awaiting a final ruling, provided they prove ownership through testimony or receipts. Here, Judge Judy applied this practically and humanely. She ordered Chris to arrange for Carrie to pick up her TV and wardrobe within 5 days, between 5 and 6 p.m., a reasonable time slot to avoid confrontation, possibly with police oversight if needed. In a real court, Carrie might have had to post a bond double the property's value to secure the order, but Small Claims Court simplifies this, requiring only a standard filing form and a fee of about $5 to $50, making justice more accessible to ordinary people. This ruling not only resolved the dispute, but also served as an educational moment, reminding both parties of their duty to respect others' property. Judge Judy, with a voice blending empathy and firmness, praised Chris. "You're a good sister for opening your home to your struggling sibling." But she offered profound advice. If you don't want to help anymore, don't expect a young woman like Carrie, who's had issues since she was 18, with a history of instability, to suddenly mature like a fully ripened adult. Set boundaries to protect yourself. The final ruling rang out like a wake. Upcall Carrie won her claim for her belongings, owed Chris nothing, and the countersuit was entirely dismissed. After the hearing, Carrie spoke with a relieved tone. Judge Judy was very fair. She made the right call. Chris, with a wry smile, advised, "Never lend money to family. They won't pay it back, and you'll lose the bond." This advice isn't just personal. It echoes data from the American Bar Association. Over 60% of family disputes involve undocumented debts, often leading to lasting rifts, with only about 30% resolving without emotional fallout. This case, to me as a screenwriter, feels like a family tragedy play, where characters learn the hard lesson of boundaries. Love must come with clarity to avoid pain. Before moving to the second case, let me pause for a moment to let you reflect. Cases like this are common in America, where state judicial systems like Washington's encourage resolving minor disputes through local courts to ease the burden on higher courts. Per the Washington State Judicial Institute, thousands of small claims cases annually, mostly about rent and property, help maintain social order. Now take a deep breath and relax, because the next case will plunge us into a different world, one of impulsive youth, late night accidents, and harsh legal accountability. The second case, a car accident brimming with drama and consequences, where an old friendship turns hostile due to alcohol, drugs, and split-second bad choices. This is the story of Brandon Welch, 22 years old, a self-storage warehouse manager, a job requiring precision and endurance, reflecting the working-class life of young Americans. She's suing Michael Hawkins, 24, a grocery store clerk, once a close friend from high school, but now an adversary for totaling her 1980 Ford Dodge Omni. The incident happened after a wild party, and Brandon seeks compensation not just for car repairs, but also medical bills and lost wages, an ambitious claim riddled with legal pitfalls. This case isn't just about material damage, it's about personal responsibility, the consequences of substance use, and how American law punishes risky decisions, especially on the road. Let's vividly recreate the incident to capture the tension. Brandon and a group of young friends, full of big dreams but tight budgets, rented a cheap motel room on Spokane's outskirts for a party. The night was a blur of alcohol, drugs, methamphetamine, per police reports, and impulsive tattoo sessions, a snapshot of early 2000s American youth party culture, when meth was spreading in rural and small urban areas like Washington. Brandon got a tattoo earlier, leaving her car keys in the room, and, per her account, Michael, her old friend, took the car without permission, driving off while drunk and high on meth. The crash happened at 11:45 p.m., when Michael fell asleep and slammed into a roadside pole, a terrifying moment with the screech of metal echoing in the dark. Brandon, in the passenger seat, was badly injured, a broken wrist requiring emergency surgery, permanent scars across her legs and lips, 2 nights in the hospital with 2 days of monitoring, plus ongoing physical therapy and painkiller prescriptions. She testified in court, voice trembling. I kept yelling at him to stop the car so I could drive, but he threatened to abandon it in Citrus Heights, a remote area where I couldn't retrieve it. Michael vehemently denied this. I was just exhausted after a 12-hour shift at the grocery store, not drunk. Brandon gave me the keys to borrow it, like when I drove it before to buy film for her camera. I wasn't on drugs then, just a few days earlier. He admitted telling police about methamphetamine use days prior, but the hospital found none in his blood, and he faced no criminal charges. The Dodge Omni, a beat-up car bought for $200 in November 1990, $9 with $100 in repairs, was totaled but miraculously still drivable, a darkly humorous detail amid the tragedy. Brandon had just paid off the car loan the weekend before, amplifying her regret. She demanded Michael cover repair costs, a $500 medical bill, confirmed by her mother in court, and boldly, 5 months of lost wages for missing a job interview at 10:30 a.m. the next day, a job she claimed was almost guaranteed, with better pay. Judge Judy scoffed. Before a big interview, you should drink milk, eat a healthy breakfast, and go to bed early, not party until midnight. That's basic responsibility. Brandon's mother interjected, claiming Michael said he was insured driver and promised to pay bills, but the judge dismissed her. This is a courtroom, not a family tea party. Let the parties speak. Digging into the legal conflict, this case hinges on contributory negligence, a core principle in American tort law. Washington state uses pure comparative negligence. Under RCW 4.22's contributory fault, meaning compensation is reduced by the plaintiff's percentage of fault. If a passenger willingly rides with a drunk or drugged driver, they may be deemed partly liable, reducing or eliminating their claim. In the landmark Washington Supreme Court case Jeshwin v. Flanagan, 1993, the court clarified that contributory negligence no longer fully bars recovery as it did before 1986, when the law changed, but if the victim's fault exceeds 50%, compensation can drop significantly. Judge Judy applied this strictly. If Michael took your car without permission and was high, you should have called the police to report it stolen, not hopped in with an aggressive, intoxicated driver. Your actions implicitly allowed him to drive, and you're responsible for that risky choice. She reiterated the lesson. Never get in a car with a drunk or drugged driver, even to save a $200 junker. Your life is worth more than property. On the criminal side, drive-and under RCW 4661, 5 or 2 in Washington is a serious offense, with a blood alcohol level of 0.08% or impairment by drugs like methamphetamine, a Schedule II controlled substance under federal DA law leading to jail time, fines up to $5,000, and license suspension. Michael escaped charges due to no direct evidence from hospital blood tests. though the police report noted his admission of prior meth use. A gap Judge Judy dismissed. The police report is enough for a civil court. Even if not for criminal charges, Brandon could still sue civilly for property damage, medical costs, and lost wages under RCW 456 adjudgments. But her contributory fault led to the dismissal of medical and wage claims. This case exemplifies the intoxicated passenger defense, common in states like Washington, encouraging personal responsibility to reduce traffic accidents. The final ruling, Brandon won $200 for the car's value, but her medical and wage claims were denied. The judge emphasized the moral lesson. You bear the consequences of your choices. The law protects victims but doesn't reward reckless behavior. Post-hearing, Michael angrily declared, "Almost everything Brandon said was a lie. She was asleep in the passenger seat while I dozed off driving." Brandon countered, "I have permanent scars and a broken wrist needing surgery. That's undeniable truth." To me, as a screenwriter, this case feels like a youth thriller film, where the protagonist learns that one wild night can change a life forever, underscoring the weight of sober decisions. As we wrap up this extended episode, these two cases aren't just legal tales, but mirrors of life and families, set clear boundaries to preserve love. On life's roads, personal responsibility is the key to avoiding tragedy. American law, especially in Washington, balances justice with education, fostering a fairer society. I hope these detailed stories bring you deep reflections, easing you into a restful sleep. If you enjoyed this, share the podcast. See you next time. Good night, dear listeners! Today, I will guide you through a civil case from the famous reality TV show Judge Judy, where Judge Judith Shainlin, the icon of sharpness and fairness, presides over a dispute between two neighbors, Tamiko Malone, a 35-year-old security officer, and Troy Wright, a 20-year-old caregiver. Malone sues Wright for allegedly throwing battery acid on his beloved Cadillac, damaging the car's paint. Wright denies everything. This is not a criminal case with thrilling plot twists like in movies, but a real-life story about grudges, suspicions, and the complex nuances of justice. Relax, close your eyes, and let me tell you a long, profound story to ponder before falling asleep. Imagine a modest apartment complex in America in 2001, where working-class families live next to each other, sharing common hallways, small yards, and sometimes unavoidable conflicts. Tamiko Malone, a security officer, is a hardworking man working night shifts to support his family, including his 9-year-old son, Darnell. His Cadillac is not just a means of transportation, but a source of pride, a symbol of effort in life. Opposite him, on the other side of the apartment complex, is Troy Wright, 20 years old, living with his mother, working as a caregiver, a young man but described by Malone as impulsive, especially when drinking alcohol. This civil lawsuit stems from an incident on April 26th, when Malone accuses Wright of holding a large plastic cup containing a liquid that he initially thought was soda, but turned out to be battery acid, and throwing it on his car, causing paint damage. Malone demands compensation for repair costs, estimated at a few $100s, a significant amount in a small claims court case, where people represent themselves without lawyers. In the American legal system, small civil cases are handled under the preponderance of the evidence standard, meaning the plaintiff must convince the court that it is more likely than not, over 50%, that the defendant caused the damage. This is a lower standard than beyond a reasonable doubt in criminal cases, but still requires specific evidence, clear testimony, independent witnesses, or documents like repair receipts. Judge Judy Shainlin, with over 20 years of experience as a family court judge before becoming a TV star, is a master at analyzing testimony. She is famous for her sharp, uncompromising style in judging illogical testimony or excessive emotions. She often interrupts when she feels someone is beating around the bush, demanding, "Don't tell me, prove it!" She turns the courtroom into a stage where the truth must be revealed through logic, not emotions. In this case, her style will be the key to uncovering contradictions, analyzing every detail, and finding the truth. On the evening of April 26th, Around 6:35 p.m., Malone prepares to drive his Cadillac to his night shift. He steps out of the apartment complex, the streetlights casting a dim glow on the old concrete walls. He starts the car, the engine rumbling softly, and sees Troy Wright standing in front of the complex with two friends. According to Malone, when the two friends leave, Wright suddenly crosses the street, holding a large plastic cup filled with a liquid that he thinks soda, the kind of cup you see at convenience stores, with a straw and lid. But instead of drinking, Wright runs toward Malone's car, splashes the liquid on the hood and body of the car, then runs along the sidewalk, disappearing into the darkness. Malone, because he is already late for work, does not stop to check immediately. He drives away carrying a feeling of annoyance, but thinking it was just a childish prank. At 3 a.m. the next morning, when he returns home after his night shift, he washes the car as a habit, and that's when he discovers something unusual. The car's paint is yellowed, peeling in the spots where the liquid touched, as if corroded by a strong chemical, possibly battery acid. Malone calls the police the next morning, but instead of prosecuting criminally, an option in U.S. law for vandalism under California Penal Code Section 594, which can result in fines or short-term jail for damages under $400, he chooses to sue civilly for compensation. Put yourself in Malone's position. He is a father, a security officer living in a not-so-luxurious apartment complex. The Cadillac is a valuable asset, perhaps something he saved for years to buy. When he sees Wright, a young man with whom he already has a grudge, acting unexpectedly, Malone immediately connects it to a previous incident in February 2001, when Wright pushed his son Darnell, causing the boy to scrape his knee and bleed. Malone and his wife confronted Wright, but he wouldn't listen, even showing a challenging attitude. In Malone's mind, the acid-throwing act is an escalation, a personal revenge. Let's analyze deeper from a screenwriter's perspective. This is a perfect dramatic moment. The dim streetlight, the hurried footsteps of Wright, the liquid splashing on the car, and Malone's fleeting glance before driving away. But in law, personal feelings are not enough. Malone needs evidence, security video, independent witnesses, or a sample of the liquid for analysis. He doesn't have those. Only his personal testimony and a recording where Wright's mother admits her son was drinking that day. Malone believes Wright was drunk, leading to impulsive behavior. In U.S. law, being drunk, negligence, it's a carelessness, but it does not automatically prove vandalism. Malone also says Wright often played too rough, with Darnell trying to hit or push, though it might just be playing. Regarding the incident where Darnell broke Wright's mother's window, Malone confirms it happened but says Wright seems reasonable, but actually isn't. Malone also recounts a scuffle after the acid incident. The next day or the same day, he corrects the contradiction. When Malone enters through the front gate of the apartment complex and Wright through the back gate, they bump into each other. Wright pushes Malone's shoulder into the gate, leading to a fight. A friend of Wright's mother intervenes, and Wright's mother calls the police. Malone agrees not to press criminal charges if Wright agrees to fix the car, but Wright refuses to talk. This pushes Malone to court. Deep analysis. This scuffle is an important plot point, suggesting personal grudge. In U.S. civil law, if a grudge leading to destructive behavior can be proven, it can strengthen the case. But Malone lacks objective witnesses for both the acid throwing and the scuffle. Moreover, washing the car before reporting to the police loses the opportunity to test the liquid, a big mistake in Judge Judy's eyes. She would look at Malone with a sharp gaze, asking, "You washed the car before reporting to the police. Do you think I'll believe you just because you say so?" Judy is famous for catching emotional testimonies without basis, and Malone is falling into a weak position. To expand on this, consider the psychological layer. Malone, as a security officer, is trained to observe threats, yet he drove away without confronting Wright immediately. This hesitation might stem from his responsibility to his job, but it undermines his credibility in court, where prompt action is key to preserving evidence. In real-life American small claims courts, judges like Judy emphasize that plaintiffs must act reasonably to mitigate damages, and delaying a report could be seen as contributory negligence, potentially reducing any award. even if the case were proven. Switching to Troy Wright's perspective, the 20-year-old defendant, Wright completely denies the acid-throwing accusation. He is not a scientist, doesn't know where to get battery acid, and especially how to contain acid in a plastic cup without it corroding. Judge Judy agrees, asking a logical question. Battery acid sulfuric acid is a strong corrosive, capable of melting ordinary plastic. How could a plastic cup hold it? This is a scientific flaw in Malone's accusation, and Judy, with her sharp analytical ability, will not overlook it. Imagine Judy, with her glasses slipped down her nose, looking straight at Malone and asking, "Are you telling me that a 20-year-old guy walks around with battery acid in a plastic cup? Do you think I was born yesterday?" This is her typical style, using logic and a bit of sarcasm to expose unreasonable testimonies. Furthermore, from a legal standpoint, this raises questions about intent and capability. In U.S. tort law for property damage claims, the plaintiff must show not only that harm occurred, but that the defendant had the means and motive to cause it. Wright's denial highlights the improbability, and without chemical analysis of the residue, which Malone washed away, the court has no way to confirm it was acid at all. It could have been something innocuous like spilled soda or even bird droppings, exaggerated in Malone's mind due to their ongoing feud. Wright recounts April 26th. He was at a music recording studio in the afternoon, then came home to organize a barbecue for a friend who was about to leave. He denies standing outside the apartment complex with two friends, as Malone said. His brother came home at 6:30 p.m. Wright arrived 2 to 3 minutes later, saw Malone driving up and looking at him maliciously. His mother advised him and his friend Kelly to go inside to avoid trouble. From 7:15 to 9 p.m., Wright was at the back of the apartment complex barbecuing, with photos and friends as witnesses, a clear alibi. Analysis in U.S. civil law: a strong alibi, like witnesses or photos, can reverse the burden, forcing the plaintiff to refute it. Wright is building a defensive wall. He wasn't there, had no motive, and no ability to commit the alleged act. Delving deeper, this alibi isn't just verbal. The mention of photos introduces tangible evidence, which in small claims court can be pivotal. Judges in these venues, unburdened by formal rules of evidence like in higher courts, can admit almost anything relevant, and a time-stamped photo of Wright at the barbecue would directly contradict Malone's timeline. Moreover, Wright's description of Malone's malicious look flips the narrative, suggesting mutual antagonism rather than one-sided aggression, a common theme in neighbor disputes where both parties contribute to the escalation. Regarding the incident with Darnell, Wright says one day, when his mother and the Malones were away, the kids were playing ball roughly, having broken his mother's window before. Wright reminded them to be careful, but Darnell threw a stone at him. When Wright turned to ask, the boy ran, fell, and Wright helped him up, comforted him, and didn't tell his parents. He believes Darnell lied to Malone. About alcohol, Wright admits to drinking a small can of beer, not drunk. Deep analysis, Wright presents himself as a responsible young man, trying to stop the kids from being naughty. This testimony directly contradicts Darnell and Malone, creating drama that Judge Judy loves to exploit. She often demands the defendant explain every detail, and if Wright has barbecue photos or witnesses, he will have a big advantage. Imagine Judy with a sarcastic smile, asking Wright, "Do you have photos of the barbecue? Show me and don't waste my time." If Wright delivers, he scores points. Psychologically, this portrayal of Wright as a caretaker figure contrasts sharply with Malone's view of him as a bully, illustrating how perspective shapes truth in civil disputes. In American law, such conflicting accounts often hinge on credibility assessments, where the judge weighs demeanor, consistency, and corroboration, factors where Wright seems to excel here. Darnell, Malone's 9-year-old son, is an important but easily doubted witness. When Judge Judy asks about the February incident, Darnell denies throwing stones, saying Wright chased him, pushed him from behind, scraping his leg. He doesn't know the reason. Judy shows suspicion. A 20-year-old man bullying a 9-year-old kid, really? In her judging style, Judy often asks direct questions to feel the pulse of witnesses, especially children, because their testimonies are easily influenced by adults. Imagine the scene of Judy, with a tone both stern and gentle, asking Darnell, "You say he pushed you. Why, what did you do before that? Don't lie to me. I know when people are lying." In U.S. law, child witnesses must be carefully evaluated, especially in civil cases where there is no jury to consider emotions. Darnell may have been guided by Malone, or his memory distorted by fear. Analysis. Darnell's testimony is a wild card. It can evoke emotion, but lacks specific details and contradicts Wright. Judy will look at the boy with a mix of pity and suspicion, trying to find the truth in the innocent but inconsistent story. Expanding on this, child testimony in American courts is governed by rules ensuring reliability, such as the Fryer-Dauberts standards for admissibility in some states, though small claims are more informal. Darnell's vagueness, not knowing why he was chased, raises red flags for suggestibility, a common issue in family influence cases, potentially leading Judy to discount it as coached or exaggerated. Wright's mother, an important witness, confirms her voice in Malone's recording. She admits Troy drank alcohol on April 26th, smelled it when he came home, and sent him out because she didn't want anyone drunk in the house. Troy returned after 15 minutes. His attitude changed from loud disrespectful to calm. When Judy asks why the change was so quick, she says it's due to attitude. Analysis. This is a detail Judy will dig deep into. She often pays attention to consistency in testimony, and the vague answer about attitude could be questioned. Imagine Judy with a sharp tone attitude. "What do you mean? 15 minutes and he's sober again? Are you protecting your son?" But Wright's mother reinforces her son's alibi. Troy was at the backyard barbecue, not wandering outside. This admission of alcohol use is double-edged. It lends credibility to her as an honest witness, but could imply Wright was impaired. However, in civil law, moderate drinking doesn't equate to liability unless directly linked to the act, and her timeline places him elsewhere. Regarding the broken window, she says the kids were playing ball noisily. She reminded them to be careful. One day she heard a bam. The window broke. Kids scattered. She kept the weapons: 3 table legs, 2 sticks, a piece of metal the kids used for sword fighting. When Troy told about Darnell falling, she showed the evidence. She emphasizes that she loves the kids, often watches them when parents are away, protecting safety. Analysis. Wright's mother is a more reliable witness because she is not directly involved in the accusation. In U.S. law, physical evidence, like weapons, they can prove context, making Malone's testimony about Darnell less convincing. Judy will like this detail because she always prioritizes specific evidence over emotions. She might say, "You kept table legs and sticks. Good, that's what I want to see, evidence, not words." This physical proof not only corroborates the rough play, but also portrays the neighborhood dynamic as one of unsupervised children engaging in risky activities, shifting some blame from Wright to parental oversight, a point Judy might hammer home to underscore responsibility in family disputes. Judge Judy Shainlin, with over 25 seasons of Judge Judy, is a master at analyzing testimony. She not only judges based on law, but also on her sharp intuition about human behavior. She often interrupts when she feels someone is lying, demanding, "Don't tell me, prove it!" In this case, she suspects Malone from the start. "Why didn't you report to the police immediately? Why wash the car before checking?" Malone explains thought it was soda, reported after returning. But Judy doesn't buy it. "Do you think I was born yesterday?" Her catchphrase when testimony lacks logic. She also doubts the feasibility of acid in a plastic cup, a scientific detail Malone can't explain. Imagine Judy with a sarcastic smile, saying, "Battery acid in a plastic cup. Are you telling a science fiction story?" Final verdict: no convincing evidence, case dismissed. Judy's approach here exemplifies her no-nonsense philosophy, rooted in her decades as a prosecutor and judge, where she views small claims as microcosms of larger societal issues like neighborly harmony. By dismissing the case, she not only applies the law but implicitly advises against letting grudges fester without proof. Analysis of Judy's style: she not only seeks the truth but also teaches lessons. She will scold Malone for irresponsible actions, washing the car before reporting, and may question Wright about alcohol. But his alibi is stronger. Judy often uses humor and sternness to clarify contradictions, like when she doubts Darnell. "Kid, Do you think I'll believe a 20-year-old chases you for no reason? She turns the courtroom into a stage where truth must shine through logic, not emotions. She also often gives moral lessons. Well, if you want to sue, bring evidence, not emotions. In this case, Judy will see Malone's story full of holes, from lack of witnesses to hasty car washing. Her style has influenced popular perceptions of justice in America, making complex legal concepts accessible while emphasizing personal accountability, a blend of entertainment and education that keeps viewers hooked. After the verdict, Malone is disappointed, saying justice has not been served, accusing Wright of jumping at him twice, even trying to stab. Malone's mother worries for her son. Wright and his mother remain silent but clearly relieved. Lesson from the case: neighborhood grudges can escalate if not resolved peacefully. In U.S. law, civil vandalism cases often end in compensation if there is specific evidence, like in the 1997 O.J. Simpson civil case, where the victim's family won due to circumstantial evidence. But without video witnesses or acid sample, Malone fails. This outcome highlights the importance of documentation in everyday disputes in today's digital age. A simple dash cam or security app could have changed everything, turning a she said into irrefutable proof. Thank you for listening. Good night, and remember, in the shadows of neighborhoods, the truth is often more complex than it appears. See you in the next episode. Dear listeners, welcome to this special extended episode of podcast crafted especially for those peaceful evenings when you wish to let your mind wander through real, life-dramatic stories from the legal world while maintaining a relaxing, reflective tone before drifting into deep sleep. Today, we will dive deeply into two cases from the legendary program Judge Judy, a place where justice is served at lightning speed, with unyielding frankness, and a dash of biting humor that makes you smile even in the most tense moments. Imagine yourself lying comfortably in bed, the bedside lamp casting a soft glow on the room, and the whisper of night winds outside the window. I will guide you through the dimly lit corridors of small claims court, where ordinary people, burdened with complex emotions, confront the consequences of their actions. We will dissect every plot point in detail, delving deeply into each dramatic moment, linking closely to real-world U.S. law so that you not only listen but also learn. And of course, we will recreate the style of Judge Judy, the iconic judge with her sharp Brooklyn accent, eyes that pierce the soul, and straightforward remarks like, "Do you think I was born yesterday?" Or, "Don't give me those stupid excuses!" She doesn't just rule, she educates, turning each case into a lively short play full of vitality. Our first case, Mary versus Johnson, is a multifaceted drama that begins with the allure of home improvement, but spirals into a web of financial accusations, emotional turmoil, and legal pitfalls. Janelle Mary, a 35-year-old homemaker dedicated to her family and household, brings suit against her ex-boyfriend Rule Johnson, a 27-year-old construction worker known for his hands-on skills but apparently lacking in reliability. Mary claims Johnson owes her $3,500 from an unpaid loan, while Johnson counters that the money was compensation for construction work he performed on her home. This dispute, played out in the intense arena of small claims court, highlights the dangers of verbal agreements, the weight of personal relationships in legal matters, and the critical role of evidence in determining truth. The case opens with Mary's compelling testimony, delivered with a mix of frustration and resolve. She recounts lending Johnson $3,500 in mid-February, a time when their relationship was rekindling after a previous breakup due to his commitment issues. Johnson approached her in tears, dramatically claiming his life was in danger and that without the money, he'd be harmed. This emotional plea tugged at Mary's heartstrings, as she believed his assurances that he wanted to make their relationship succeed. However, she now feels deeply deceived, as the money came from a hard-earned home refinance to cover a $70,000 IRS tax debt from stock withdrawals. Johnson, aware of the impending loan disbursement, timed his request perfectly, adding a layer of calculated manipulation to the narrative. delving deeper into this initial plot point. The alleged loan's emotional underpinnings raise red flags under U.S. law. In California, where such cases are common, verbal agreements for loans are potentially enforceable under contract law if they satisfy elements like mutual assent and consideration. But the Statute of Frauds, Civil Code Section 1624, mandates written documentation for agreements over $500 in certain contexts, though short-term loans may qualify as exceptions with strong oral evidence. Real-world precedents, such as Monarco v. Lo Greco 1950, illustrate how oral promises can be upheld if partial performance or detrimental reliance is proven, but Mary's lack of specifics on the money's use, beyond Johnson's vague, life in danger claim, weakens her position initially, setting up a tense battle of credibility. Johnson's counter, testimony shifts the focus to a construction project from the previous summer, where he and his brother allegedly discussed a comprehensive job valued at $8,000 to $10,000, encompassing skylights, countertops, tiling, and double front entry doors. They began around July 24th or 25th, laboring for 3 days before Mary abruptly halted the project, stating she would complete it herself. Johnson claims she paid only a $500 check for materials, leaving labor unpaid. He confirms the check in 3 days' work, admitting there was no written contract, only a verbal understanding, which Judge Judy immediately scrutinizes, her voice laced with incredulity. No written contract. In construction. That's a recipe for disaster, sir. This absence of documentation is a pivotal plot twist, mirroring countless real U.S. cases where verbal agreements lead to disputes. Under California's Business and Professions Code Section 759, home improvement contracts over $500 must be in writing to protect consumers from fraud or incomplete work, with violations potentially barring contractors from collecting payment. Johnson's invocation of quantum meruit, an equitable doctrine allowing recovery for the reasonable value of services to prevent unjust enrichment, adds legal depth. As seen in Maglica v. Maglica 1998, quantum meruit can apply in non-contractual scenarios, but courts require clear proof of the work's value and benefit conferred. Johnson struggles here, claiming $4,000 for 3 days' work, which Judge Judy dismisses as unreasonable. $4,000 in 3 days. Do you think I'm new to this, sir? That math doesn't add up. The case intensifies with details of the work performed. Johnson describes demolishing and installing one countertop, insisting only the sink portion remained unfinished. Mary counters vehemently. There were 3 countertops. Johnson botched the second, left the third untouched, rendering her kitchen unusable. She hired professionals to rectify the mess, underscoring the substandard quality. This exchange highlights a common construction law issue, breach of implied warranty of workmanship, where even verbal contracts imply competent performance, as in Pollard v. Saxon Yolas Dev. Co. 1974. Mary's firing of Johnson for verbal insults further complicates matters, introducing elements of harassment or hostile environment, though not formally charged. Verbal abuse in relationships can tie to broader protections under the Violence Against Women Act, Aviegue, but here it serves to justify non-payment for incomplete work. Judge Judy's interventions are masterful, channeling her no-nonsense style to maintain order. When Johnson interrupts, she warns, "Keep that big mouth closed, or I'll decide this in a way you won't like." A classic Judy threat that silences the room. Johnson's lack of receipts for materials, like the sink he claims to have purchased, seals his fate. His witness is ejected for disruptive behavior, leaving him without corroboration. Psychological insights emerge. Johnson's post-relationship bitterness suggests resentment, while Mary's resolve indicates empowerment after deception. This dynamic is reminiscent of cases like Marvin v. Marvin 1976, where oral agreements in relationships are scrutinized for intent. The verdict arrives with Judy's decisive flair, in favor of Mary for $3,500. "That's how I handle a case with a big mouth," she declares, her humor underscoring the ruling's finality. The conclusion reverberates with personal jabs. Johnson accuses Mary of obsession and calls her crazy, while she labels him, revealing unresolved emotional scars. This outcome teaches that verbal agreements, while viable, demand evidence. Without it, credibility wins. In broader U.S. law, Small claims courts handle millions of similar disputes annually, emphasizing the need for written records to avoid such nightmares. Extending the analysis, consider how this case parallels Judge Judy episodes where ex-partners clash over money, often blending personal grudges with legal claims. The psychological toll, Mary's sense of betrayal, Johnson's defensiveness, mirrors studies on relational disputes where trust erosion leads to litigation. Lessons abound document everything, especially in mixed personal professional dealings. Seek written contracts to invoke protections like mechanics liens, Civil Code Section 8400, which Johnson considered but abandoned. Ultimately, the verdict affirms justice's role in restoring balance, a theme Judy embodies. Post-divorce disputes, forgotten property battles, insurance claims examined, verbal agreements challenged, and the verdict's lasting lessons. The second case, Gilbreth versus Brown, delves into the lingering shadows of divorce, where a house fire ignites a dispute over property, insurance, and unfulfilled promises. Steve Gilbreth, a 30-year-old electrician reliant on his tools for livelihood, sues his ex-wife Kristen Brown, a 30-year-old food care supervisor, for a share of insurance proceeds from their former shared home's destruction. This narrative explores the finality of divorce decrees, the pitfalls of verbal post-separation agreements, and the emotional residue of ended marriages, all under Judge Judy's discerning eye. Gilbreth's testimony sets a somber tone. Married since October 7, 1989. They separated in January 1998, with Gilbreth initially residing in the house before being asked to leave. The divorce finalized on October 29, 1999, and just a month later, November 1999, the house burned. He left personal property there upon moving out, with Brown's verbal consent to store it. He returned sporadically for items like clothes, but left tools essential for renovating their son's room, tools he used daily in his trade. He has the divorce decree, admitting it allocated all property. The tools were for the renovation promised to complete. A verbal agreement allowed storage. No lawyer then, he signed for the kid's sake, friends for over 20 years. He trusted her word, believing she knew about the tools, renovation materials, and inherited items like blankets from his mother and grandmother. This setup invites deep scrutiny. California, a community property state under Family Code Section 760, mandates equal division of marital assets at divorce, but post-decree property is separate unless specified in the decree. Verbal agreements after divorce are tenuous, often unenforceable if contradicting the decree, as in Remarriage of Thorne 1981, where oral modifications required written confirmation to hold. Gilbreth's claim of inheritance materials in the decree is misinterpreted. The clause protects future inheritances, not existing items, highlighting a common layperson error in legal interpretation. Brown's denial is straightforward. No verbal agreement existed, and she was unaware of the tools or renovation items. This contradiction forces a credibility assessment where Judge Judy excels, probing with questions like, "You expect me to believe that after 20 years she just forgot?" Her sarcasm exposing weaknesses. Judge Judy's analysis is thorough and unflinching. The decree explicitly states each party retains household items and furnishings in their possession, free and clear of claims, meaning at the fire's time, all in Brown's possession was hers alone. She emphasizes the decree's detail, covering the house, vehicles, and notes Gilbreth's failure to include a separate clause listing retrievable items. You had your chance at divorce to spell this out. You didn't, sir. That's on you. His admission of no prior advice underscores the importance of legal counsel in divorces. On insurance, Judy clarifies Gilbreth has no interest post-divorce unless Brown held items in trust, which she denies, a principle upheld in State Farm Fire and Cas. Covey Lewis 1989. Where post-divorce insurance benefits accrue to the titled owner. The inheritance materials. Argument crumbles under Judy's scrutiny. The decree's language on inheritance or anticipated property refers to future bequests, not tools or blankets. "You should have taken those blankets 2 years ago," she quips. "They're not electrical tools, and you don't remodel a room with quilts." This humorous dismissal lightens the tension while reinforcing legal precision. Psychologically, Gilbreth's persistence suggests unresolved attachment to the past. while Brown's relief indicates a desire for closure, dynamics common in post-divorce litigation, as studied in family law research showing 30% of divorces lead to subsequent disputes. The verdict is swift and conclusive, case dismissed. This is straightforward, Judy states. The decree assigns property individually, no claims. You missed your opportunity to list these items for retrieval. No rights now. The conclusion echoes with finality. Brown expresses joy at closure, hoping it ends. Senseless threats. Gilbreth disagrees but accepts, revealing lingering resentment. Extending the dissection, this case parallels in Remarriage of Valley 2014, where verbal post-decree promises were invalidated without written amendment. Insurance claims post-fire often hinge on ownership at lost time, as in Californians. Code Section 2071. Lessons. Always amend decrees for reserved property. Verbal trusts are unreliable. In U.S. courts, millions of post-divorce disputes arise annually, emphasizing comprehensive settlements. These cases, dissected in depth, reveal core truths. Verbal promises falter without evidence. Divorce decrees are ironclad barriers. Mary's victory underscores credibility's power in loan disputes, linking to laws like quantum meruit and contract requirements, teaching documentation's necessity. Gilbreth's loss highlights decree finality, insurance ownership, and verbal agreement pitfalls, urging thorough legal planning. Judge Judy's verdicts, delivered with wit and wisdom, restore balance, reminding us justice heals but preparation prevents pain. As you drift to sleep, ponder in life's courtroom, foresight is the best defense. Good night. Imagine it's late, the world is quiet, and you're tucked into bed, craving a story that pulls you in, stirs your emotions, and makes you think. We're stepping into the courtroom of Judge Judy, where tempers flare, truths are laid bare, and justice cuts through the chaos like a blade. Tonight, we've got two cases that'll grip you tighter than a suspense novel. First, a violent showdown in a church parking lot, where a teenager faces a brutal attack in a fight for justice. Then, a dispute over a sofa that carries the weight of broken promises, a death and a battle for fairness. These stories are more than lawsuits. They're windows into betrayal, regret, and the human struggle to make things right. We'll dive deep into every detail, weave in the intricacies of United States law, and channel Judge Judy's razor-sharp wit to bring you a narrative that's as thought, provoking as it is captivating. Let's step into the courtroom. On May 9, 2001, a quiet church parking lot in a small American town transformed into a battleground. Justin Storrs, a lanky 16-year-old high school student, and his father, Lance, a 43-year-old mechanic with calloused hands and a protective heart, are suing Chris Elim, an 18-year-old lawn care worker and former classmate of Justin's. The charge is assault, and it's not a minor scuffle. Justin claims Chris attacked him with fists and a belt, leaving him with a mild concussion, welts across his back, and a shaken sense of safety. They're seeking $5,000, the maximum for small claims in many states, to cover medical bills, pain, and suffering. But Chris isn't rolling over. He's countersuing, alleging Justin stole money from him, igniting the whole ordeal. This case is a powder keg of teenage grudges, vigilante justice, and the consequences of crossing lines that can't be uncrossed. Justin's testimony is the kind that sends chills down your spine. It's a sunny afternoon, and he's riding shotgun in his friend Brian's beat, up sedan, parked in the church lot after grabbing burgers at a local diner. They're chatting with another friend, Jeremy, laughing about something trivial, when a car screeches into the lot. It's Chris Elim, eyes blazing with fury. Justin barely has time to process before Chris storms to the passenger window, his fists hammering the glass so hard it rattles. "Get out!" Chris shouts, his voice a low growl as he starts counting down from 10. 10, 9, 8. Each number drips with menace like a predator circling its prey. Brian, behind the wheel, freezes, his knuckles white on the steering wheel. Two of Chris's buddies appear, grabbing Brian and pinning him against the car to keep him out of the fray. What happens next is pure chaos. Chris circles to the driver's side, where the door's unlocked, and climbs in. Justin, still buckled in, is trapped. Chris unleashes a barrage of punches, hard, deliberate blows to Justin's head, ribs, and back. The car feels like a cage, the air thick with the sound of fists meeting flesh. Then, in a move that feels ripped from a street fight, Chris rips off his leather belt, the buckle glinting in the sunlight, and starts whipping Justin. The leather snaps against Justin's back, leaving angry red welts that burn with every strike. Justin curls into a ball, knees to his face, arms shielding his head, trying to disappear into himself. He doesn't fight back, just endures, his world reduced to pain and fear. As Chris climbs out, he leans in close, his breath hot against Justin's ear, and snarls, "If I find out you took my money, I'll end your life." The threat hangs heavy, a promise of more violence to come. The aftermath is grim. Justin's left with a mild concussion, documented by an emergency room visit, follow-up medical reports and photos of his injuries, deep red welts crisscrossing his back, scratches from Chris's nails as he tried to drag Justin out of the car, bruises blooming across his ribs. He files a police report, but no charges stick. Why, Chris, at 17 and days from turning 18, falls into what Justin calls a criminal twilight zone, a legal limbo where prosecutors hesitate to act, especially for a juvenile case teetering on the edge of adult court. Justin's adamant he didn't steal any money. This was an unprovoked attack by someone he once considered a friend, a kid he'd shared hallways and classes with. The physical scars are bad enough, but the betrayal cuts deeper. Imagine being 16, trapped in a car, your world shrinking to the rhythm of blows and the sting of leather. This isn't just a fight, it's a violation. A moment that rewires how you trust the world. Chris Ellum steps into the courtroom with a different narrative, one fueled by righteous anger and a sense of betrayal. He paints Justin as a thief, a kid with a reputation for sticky fingers. Back in February 2001, Chris says Justin stole money from a friend during gym class, a claim he and another buddy, Tommy Evans, confronted Justin about at the time. Fast forward to May 9th, and Chris is fresh off a basketball game, sweaty and tired, when he checks his locker and finds $35 missing. He's convinced Justin's the culprit, especially since Tommy claims he saw Justin in a restricted locker room where the team's wallets were kept. The money wasn't just pocket change. It was for a Mother's Day gift for his mom, a detail that makes Chris's blood boil. When he spots Justin cruising through town, he doesn't hesitate. He follows him to the church parking lot, ready for a reckoning. Chris confirms he approached the passenger window, banging on the glass and demanding Justin get out. When Justin doesn't budge, and Brian, the driver, starts yelling, Chris circles to the driver's side where the doors open. He climbs in and admits to throwing punches, first to Justin's face, then a second to his shoulder. Justin, he claims, fought back, turning it into a brief scuffle. But here's where Chris's story splits from Justin's. He denies using a belt. He says his hand got tangled in a seatbelt, which might have grazed Justin once, but there was no whipping, no sustained attack. His narrative is shaky, though. The police report lists the stolen amount as $10, not $35, and Chris insists the $10 figure is a mistake, maybe tied to the February incident. Tommy, his witness, claims Justin was in the locker room, but never reported it to the principal, weakening the accusation. It's a story built on conviction, not evidence, and the cracks are showing. Chris doesn't shy away from his mistake. He admits he took the law into my own hands and calls it very, very wrong. The consequences hit like a freight train. He's suspended for the rest of the school year, missing graduation, prom, and a coveted spot in a firefighter training program. His dreams of serving his community are on hold, all because of a moment of rage. Yet, even as he owns his error, there's a stubborn edge to his voice. He's still convinced Justin's a thief, and that $35 wasn't just money. It was a piece of his pride, a gift for his mom he couldn't deliver. Chris is a young man torn between regret and defiance, caught in the fallout of his own choices. Let's zoom out and view this through the lens of United States law, because this case is a textbook example of assault and battery, with a side of vigilante justice gone wrong. In most United States states, assault is an intentional act that creates a reasonable fear of imminent harm. Chris's countdown from 10, paired with his aggressive banging on the car window, is a clear assault. Justin had every reason to fear what was coming. battery, meanwhile, is the unlawful physical contact and Justin's injuries. A mild concussion, welts, scratches, and bruises are undeniable proof. The medical reports, emergency room visit, and photos of those belt marks seal the deal. This wasn't a single errant punch, it was a sustained attack, with the belt adding a layer of cruelty that's hard to dismiss. In civil court, the burden of proof is a preponderance of the evidence. More likely than not, and Justin's evidence is overwhelming. Those welts aren't the result of a seatbelt graze. They're the mark of intent. Chris's countersuit, though, is a legal house of cards. He accuses Justin of theft, but where's the evidence? Tommy's claim that Justin was in the locker room is hearsay without corroboration, and he didn't report it to authorities at the time. The discrepancy between $10 in the police report and Chris's claim of $35 muddies the water further. In United States civil law, you need concrete proof to win a claim, and Chris's accusation is all smoke, no fire. His decision to confront Justin himself, what legal scholars call self-help, is a fatal misstep. The law doesn't allow you to bypass the courts to settle scores, no matter how wronged you feel. If Chris had taken his theft allegations to the police or school authorities with solid evidence, he might have had a case. Instead, he climbed into that car and threw punches, an act that Judge Judy rightly calls out as making him judge, jury, and prosecutor. There's more to unpack legally. Judge Judy notes that Chris's actions could have been charged as trespass with intent to commit a felony, a serious crime in states like California, Texas, or New York. Entering someone else's vehicle without permission, especially to commit assault, fits the definition of criminal trespass in many jurisdictions. Depending on the state, this could have escalated to felony assault, given the concussion and sustained attack, or even burglary, since entering a vehicle with intent to commit a crime can qualify. The fact that no criminal charges were filed is surprising but not unprecedented. Justin's reference to a criminal twilight zone points to a real issue in United States Law 17. Year-olds often straddle the line between juvenile and adult court. In many states, prosecutors may decline to pursue cases near the age cutoff, especially for non-felony assaults, due to jurisdictional complexity or resource constraints. Juvenile courts focus on rehabilitation, but a case like this, with a defendant days from 18, might fall through the cracks. In civil court, though, Chris's age offers no protection. His admission, "I took the law into my own hands," is a legal death knell handing Justin the win. This case also touches on broader societal issues. Chris's suspension and loss of graduation privileges were, as Judge Judy put it, entirely appropriate. Under most United States school codes, physical confrontations, even off campus, can trigger disciplinary action if they disrupt the school environment or involve students. Chris's punishment wasn't just about the fight. It was about sending a message that violence has no place in a community. His lost shot at the firefighter program is a gut punch, a reminder that one impulsive act can derail years of ambition. For Justin, the $5,000 award covers medical bills, pain, and suffering, but it can't erase the trauma of being attacked by someone he knew. This case is a microcosm of accountability. Chris's rage cost him dearly, while Justin's courage in court brought him justice, if not peace. Judge Judy doesn't mince words. She dismisses Chris's countersuit with a flick of her wrist. No evidence, no case. She tears into Chris for playing vigilante, pointing out that his suspension, missed graduation, and lost opportunities were his own doing. The evidence, Justin's medical records, photos of welts and scratches, and consistent testimony, paints a clear picture of a deliberate, brutal attack. Those belt marks aren't the result of a seatbelt mishap. They're proof of sustained violence, a calculated escalation from fists to leather. Judy's stunned the police didn't arrest Chris, noting that his actions could have been charged as a felony, trespass with intent to harm, or worse. Her verdict is swift and decisive. Justin gets the full $5,000, a resounding victory in small claims court. Chris, still muttering that it was just a few scratches, leaves the courtroom humbled, his defiance crumbling under the weight of the truth. Justin, scared but vindicated, walks away with justice, though the emotional wounds may linger longer than the physical ones. This case is a stark reminder of the cost of vengeance. Chris let his anger override reason, and it cost him his senior year, his dreams, and $5,000. Justin, meanwhile, showed the courage to face his attacker in court, proving that standing up for yourself can lead to justice, even when the criminal system falters. The law doesn't care how mad you are. Take it to court, not a parking lot. Our second case shifts from fists to feelings, but the stakes are no less intense. Amy Pollock, a 34-year-old customer service representative with a knack for keeping receipts, is suing Diane Frederick, a 46-year-old healthcare manager with a calm demeanor but a stubborn streak. The dispute, a sectional sofa, seemingly mundane but steeped in the weight of love, loss, and unpaid debts. Amy wants $2,250, the sofa's full value, claiming Diane's holding it hostage after Amy paid off its lingering debt. Diane insists it was a gift from her late boyfriend, Gregory, who also happened to be Amy's ex. This isn't just about furniture, it's about broken promises, a death that changed everything, and a fight for fairness in the shadow of grief. Amy's story begins years ago, when she and Gregory Laffer were young and in love, pooling their money to buy a sleek sectional sofa on credit. It was a big purchase, a centerpiece for their shared apartment, a symbol of their life together. But love doesn't always last. When they split, they divided the sofa, each taking a piece, with Gregory promising to pay off the remaining balance. It was a verbal agreement, sealed with the trust of a fading relationship. But Gregory didn't keep his word. Time passes, and Gregory moves in with Diane, his new girlfriend, bringing the reassembled sofa along as a gift for their home. Then tragedy strikes. Gregory dies, leaving behind memories, debts, and that sofa. Amy's world shifts again when she gets a call from the credit company. The sofa's unpaid balance, over $700, is threatening her credit score, a financial albatross she didn't expect. With no choice, she pays it off, meticulously saving every receipt to prove it. Now she's suing Diane for $2,250, the sofa's original cost, arguing that Diane's been using it for a year and a half without contributing a dime. Amy tried reaching out, phone calls, texts, even a middleman, but Diane ignored her for months, refusing to discuss the sofa or its debt. Only recently, after Amy filed the lawsuit, did Diane's friend call to say Amy could pick up the sofa. Amy's not buying it. This last-minute offer feels like a dodge, a way to avoid accountability. She doesn't want the sofa back. It's a painful reminder of Gregory and their past. She wants cash, a chance to close this chapter and move on. Her frustration is raw. She's paid for someone else's mistake, and now she's stuck battling for fairness in a courtroom. Diane's side is simpler, but it's not airtight. She says Gregory gave her the sofa as a gift for their shared home, a gesture of love with no strings attached. When Amy started demanding payment, Diane claims she offered to return the sofa through a mutual friend, but only after Amy sued, 18 months after Amy's initial request. Diane's defense is that she shouldn't be on the hook for Gregory's debts. The sofa was hers, fair and square, and she's willing to give it back to avoid trouble. But her story raises questions. Why ignore Amy's calls for over a year? Why wait until the lawsuit to offer the sofa's return? Diane's calm exterior hides a strategic pivot, a way to dodge liability while clinging to the moral high ground. She paints herself as a grieving partner, caught in the crossfire of Amy's financial woes, but her delayed response tells a different story. This case is a classic property dispute, and United States law provides a clear framework to untangle it. Let's break it down. Amy and Gregory bought the sofa on credit, making them jointly liable for the debt. When they split, Gregory's promise to pay was a verbal contract, binding in theory, but hard to enforce without written proof. His failure to pay left Amy liable, and her payment of over $700 to protect her credit gives her a strong claim to the sofa's value or possession. But here's the complication. Gregory gifted the sofa to Diane. In United States property law, a valid gift requires 3 elements: intent to give, delivery of the item, and acceptance by the recipient. Gregory intended the sofa as a gift, delivered it to Diane's home, and she accepted it by using it for a year and a half. Legally, it's hers, unless Amy can prove otherwise. Amy's argument hinges on the debt. Since she paid off the sofa, she believes Diane should compensate her for its value. But the law draws a firm line. Diane wasn't party to the credit agreement. In most United States jurisdictions, creditors can't pursue third parties for someone else's debt unless they co-signed or assumed liability. Diane's possession of the sofa doesn't make her responsible for Gregory's failure to pay. Amy's real recourse would have been against Gregory's estate, but since he's deceased, that's likely a dead end, especially in small claims court where probate issues rarely surface. The sofa itself, though, is tangible property, and Amy's payment strengthens her claim to it, not its cash value from Diane. Judge Judy's solution, returning the sofa, falls under equitable relief, a common remedy in property disputes. Amy can reclaim the sofa, but she can't force Diane to pay for a gift received in good faith. In a state like California, Amy could have explored a claim for unjust enrichment, arguing Diane benefited unfairly from the sofa without contributing to its cost. But such claims require proof of a direct benefit, and in small claims court, the lack of a contract between Amy and Diane makes it a tough sell. Diane's delayed offer to return the sofa, 18 months after Amy's initial request, suggests she hoped to keep it without consequence, but it doesn't change the legal outcome. The law prioritizes evidence over emotion, and Amy's emotional stake, while real, doesn't translate to dollars. This case also highlights the limits of small claims court. The $2,250 amount Amy seeks is within the typical small claims cap, for example, $7,500 in California, $5,000 in Texas. But her demand for cash rather than the sofa pushes the boundaries of what the court can award. Judge Judy's ruling balances fairness with legal reality. Amy gets the sofa, but not the closure she craves. Judge Judy cuts through the emotional fog with her trademark clarity. Diane's not responsible for Gregory's debts. End of story. The sofa was a valid gift, and Diane's under no legal obligation to pay Amy $2,250. But Amy's payment of the debt gives her a right to the sofa itself. Judy orders Diane to return it within 5 days, and Amy, knowing Diane's address, agrees to pick it up. It's a practical ruling, grounded in property law, but Amy's not satisfied. She wanted cash, a clean break from the past, not a used sofa tied to memories of Gregory. Diane walks away unscathed, her wallet intact, her offer to return the sofa a belated olive branch. Amy leaves with a bittersweet victory, a physical reminder of loss, not the financial relief she sought. This case is a lesson in the limits of justice. Amy's pain, paying for a dead ex's mistake, is real, but the law doesn't bend for feelings. Diane's possession of the sofa was legal, and without a contract tying her to the debt, Amy's stuck. Sometimes you get the thing you fought for, but not the closure you need. As we close tonight's episode, these cases linger like echoes in a quiet room. Stores v. Alim is a cautionary tale about the cost of vengeance. Chris Alim let his anger override reason, and it cost him his senior year, his dreams, and $5,000. Justin Stores, scarred but resilient, showed the courage to face his attacker in court, proving that justice can prevail, even when the criminal system falters. Pollock v. Frederick reminds us that objects, a simple sofa, can carry the weight of love, loss, and betrayal. Amy fought for fairness, but the law gave her only what she was owed, not what she deserved. Judge Judy's courtroom is a crucible, burning away excuses to reveal truth. These stories challenge us to think, what would you fight for, and how far would you go? Would you take it to court, or let it go? As you drift off, let these questions linger, and let justice light your dreams.